Welcome to this explainer. Today, we're jumping right into a really profound legal and ethical dilemma, one that forces us to look at the absolute limits of the law when it collides with finite healthcare resources. We're going to be unpacking a landmark 1997 ruling from the Constitutional Court of South Africa, case CCT 3297, a case that asks a seemingly impossible question.
Think about this for a second. If a hospital literally doesn't have enough machines to save everyone, who actually decides who gets to live? It's an agonizing, deeply uncomfortable question, but it sits right at the very heart of the source material we're breaking down today. It is, at its core, a story about the devastating clash between infinite human need and starkly limited state resources.
Part 1. The Heartbreaking Dilemma. The Story of Mr. Soobramoney.
Let's ground this right away, because behind all the heavy legal theory is a very real human being. Mr. Thiagraj Soobramoney, the appellant in this case, was facing a truly grim medical reality. He was a 41-year-old unemployed man battling a compounding, honestly overwhelming series of health issues. He had diabetes, ischemic heart disease, and in 1996 he suffered a stroke. That very same year, his kidneys failed. The condition was irreversible. Without regular renal dialysis, a process that requires a machine to clean your blood 2 to 3 times every single week, his life would abruptly end. Desperate, he turned to the renal unit of the Addington State Hospital in Durban for help.
But he immediately hit a massive roadblock. 20. That's it. That is the exact number of dialysis machines the Addington Hospital had available to serve not just their immediate area, but the entire KwaZulu-Natal province and even parts of the Eastern Cape. And to make matters worse, some of those 20 machines were in really poor condition. When you consider each treatment takes 4 hours plus another 2 hours just to clean the machine, the math simply does not add up. The hospital was already operating at maximum capacity, so they had to turn Mr. Soobramoney away.
Moving on to Part 2. The Constitutional Clash. Section 27, subsection 3 versus Section 11.
Desperate for more time, Mr. Soobramoney takes this matter to court, and he actually escalates it all the way up to the Constitutional Court. His legal team structured a brilliant argument, combining 2 incredibly powerful constitutional clauses. First, they invoked Section 11, which simply and powerfully states, everyone has the right to life. Then, they paired that with Section 27, subsection 3, which guarantees that no one may be refused emergency medical treatment. The argument was straightforward. Mr. Soobramoney's need for dialysis to prevent his death was an emergency, so refusing him violated both his right to emergency care and his fundamental right to life.
But here's the catch, and it's a big one. Rights don't just exist in a vacuum. The state countered this by pointing to another section of that very same Constitution, Section 27, subsection 2. This clause explicitly limits the state's healthcare obligations. It says the state must take reasonable measures, sure, but specifically within its available resources. So suddenly, the court is forced to reconcile the absolute promise of human rights with the stark reality of empty hospital budgets. Which brings us to Part 3, defining an emergency, catastrophe versus chronic.
To figure this out, the judges had to essentially put a single word under the microscope. What exactly qualifies as an emergency under the law? Judge Cheskalson, who delivered the main judgment, defined emergency medical treatment in a very specific way. He said it's a sudden catastrophe calling for immediate remedial treatment. You know, the whole purpose of Section 27.3 is to ensure that victims of unforeseen disasters, think a train accident or someone suddenly collapsing in the street, aren't turned away from an emergency room just because of bureaucratic red tape. It's about an immediate, passing event where quick treatment averts immediate harm.
And here is where the court draws a massive legal line in the sand. Chronic renal failure, they argued, is not a sudden catastrophe. It's an ongoing, deteriorating, totally incurable state of affairs. Needing maintenance dialysis multiple times a week for the rest of your life is fundamentally different from needing a broken leg set after a car crash. Because of that distinction, the court ruled that Mr. Soobramoney's situation fell strictly outside the legal protection of the emergency clause.
Let's look at Part 4, the burden of scarcity, the macro reality. Having ruled out the emergency clause, the court now has to evaluate the case under the state's broader obligation to provide health care within those available resources. To do this, they really had to examine the harsh macroeconomic reality of the state health system. And the financial context they were presented with was just staggering. The KwaZulu-Natal Department of Health was anticipating a massive budget overspend of 700 million rand for that current year. We're not talking about bureaucratic stinginess here.
The system was literally hemorrhaging money, and brutal cutbacks were the absolute only way to keep the entire provincial health infrastructure from totally collapsing.
To put that into perspective on a micro level, Dr. Sarala Devi Naiker, the head of the renal unit, laid out the math. Keeping just one chronically ill patient on dialysis twice a week cost the state roughly 60,000 rand per year. If the court ordered the state to provide this for Mr. Soobramoney, they would legally have to provide it for every single person in the country suffering from chronic renal failure. The resulting cost would completely obliterate the national health budget. It would strip funds from preventative care and pretty much every other essential medical service.
Because of this extreme scarcity, Addington Hospital had to use incredibly strict triage guidelines. The primary requirement just to enter the dialysis program was that the patient must be eligible for a kidney transplant. Dialysis was meant to be a bridge to a cure, not a permanent maintenance plan. And because Mr. Soobramoney had pre-existing ischemic heart disease and had already suffered a stroke, he was medically disqualified from ever receiving a transplant. So by default, under the hospital's rules, he was disqualified from the dialysis program too.
Think about the numbers here. The hospital was under an impossible strain. Ideally, those 20 machines should be handling about 60 patients. In reality, they were treating 85. The nurses were stretched incredibly thin. Even with those incredibly strict guidelines we just talked about, they could barely manage the 30% of applicants who actually qualified. The court realized that if they forced the hospital to abandon its own guidelines to admit Mr. Soobramoney, the entire overburdened program would just collapse. And then no one, not the curable transplant candidates and not the chronically ill, would benefit at all.
This leads us to our final section, Part 5, the final verdict, ethics and finite resources. So the Constitutional Court was staring down an absolutely agonizing decision. On one side, you have deep human compassion for a dying man, and on the other, the cold, hard mathematics of finite resources in a developing nation. Ultimately, their verdict was definitive. The appeal was dismissed. The judges ruled that the state's failure to provide renal dialysis for all chronic patients did not constitute a breach of its constitutional obligations. The hospital's guidelines were found to be rational, fair, and applied in good faith. Despite the court's profound sympathy for Mr. Soobramoney and his family, they simply could not legally mandate his treatment. The court's reasoning really hinged on what they called a holistic approach. In a country dealing with massive disparities, they argued that true human rights have to look at the broader community. The right to life also encompasses the right to housing, clean water, and basic preventative care. Prioritizing one individual's highly expensive terminal care would basically mean actively stripping basic life-saving resources from thousands of other citizens. The Constitution, they said, does not demand that.
The judges also leaned heavily on the concept of institutional modesty. Judge Chaskelson actually cited a powerful English case, noting difficult and agonizing judgments have to be made as to how a limited budget is best allocated to the maximum advantage of the maximum number of patients. That is not a judgment which the court can make. Basically, the Constitutional Court acknowledged that frontline medical professionals and health administrators, not judges in a courtroom, are the ones truly equipped to make these tragic triage decisions.
Judge Albie Sachs added a deeply philosophical layer to this in his concurring judgment. He stated, "Interdependence is not a social ideal, but an inescapable fact. The scarcity of resources forces it on us." He made the point that rationing access to life-prolonging resources isn't actually a failure of human rights. In a world of absolute scarcity, rationing is integral to a human rights approach because it ensures a principled rather than chaotic distribution of whatever help is actually available. Which leaves us with this final, truly provocative thought. Can a constitutional right ever truly guarantee life? Or, as the Soobramoney case suggests, does the law merely serve to define the boundaries of our agonizing choices in a world strictly governed by finite resources? It's a heavy question to carry, for sure, but understanding it is absolutely crucial to grasping the real-world intersection of public health and human rights. Thank you so much for joining me and exploring this case with me today on This Explainer.